I never thought I would be sitting in a lawyer's office at 42 years old, discussing how my homeowners association was sabotaging my rental business. But there I was on a cold Tuesday morning in Phoenix, Arizona, wondering how everything had spiraled so far out of control. My name is Franklin Anderson, and I had worked my entire adult life to build a modest real estate portfolio in the Sunrise Meadows community, a planned neighborhood on the outskirts of Phoenix that had seemed like the perfect investment opportunity back in 2019. I owned 4 properties there, 3 of which I rented out to hardworking families who just wanted a decent place to live. I had followed every rule, dotted every I, crossed every T, or so I thought. The properties were registered with the county. I paid my taxes on time, and I had even gone through the proper channels with the HOA when I first started renting them out 5 years ago. Everything changed when Sharon Patterson became the HOA president 6 months earlier. Sharon was the epitome of what people call a Karen, a 50-something woman with a severe blonde bob, perpetually pursed lips, and an apparent mission to make everyone's life miserable. She had moved into the neighborhood 3 years ago, immediately joined the HOA board, and worked her way up through a combination of persistent complaining and outlasting everyone else who got tired of dealing with the drama. The first sign of trouble came in early September when one of my tenants, a young couple named Miguel and Sofia Rodriguez, called me around 8 in the evening. Miguel sounded agitated, which was unusual because he was typically laid back and easy to work with. "Franklin, we need to talk about something that happened today," Miguel said, his voice tight with frustration. "What's going on?" I asked, setting down the book I had been reading. "This woman from the HOA came by today. Blonde hair, kind of intense. She told us that our lease might not be valid because she claimed the property was not properly approved for rental." My stomach dropped. "What exactly did she say?" "She said that you never got the proper approval from the HOA to rent out the property, and that we might need to vacate within 30 days. Sophia is really stressed about this, Franklin. We just had the baby 3 months ago, and we cannot handle moving right now." I felt anger rising in my chest, but I kept my voice calm. "Miguel, listen to me. That property is absolutely approved for rental. I went through the entire process years ago when the previous HOA board was in charge. I have all the paperwork. This woman has no idea what she is talking about." "Are you sure? Because she seemed pretty confident and she left us this letter." He paused. "It is on official HOA letterhead and everything." "Take a photo of that letter and text it to me right now," I said, already getting up to find my laptop. "And do not worry. This is going to be handled." 5 minutes later, my phone buzzed with the photo. The letter was indeed on official Sunrise Meadows HOA letterhead, and it made my blood boil. It stated that the property at 4521 Desert Bloom Drive was operating as an unauthorized rental, that the HOA had no record of rental approval, and that the tenants were advised to seek alternative housing arrangements as the HOA would be taking enforcement action against the property owner. It was complete nonsense, and I had the documentation to prove it. I immediately went to my file cabinet where I kept all my HOA correspondence and pulled out the approval letter from 2020, signed by the previous HOA president, Robert Chen. It clearly stated that my properties at 4521 Desert Bloom Drive, 4598 Desert Bloom Drive, and 4612 Cactus Way were approved for rental purposes, subject to standard HOA rules and regulations. I called Miguel back. "I found the approval letter. This is harassment, pure and simple. Do not let this stress you out. I am going to deal with the HOA directly tomorrow." That night, I barely slept. I kept thinking about Sharon Patterson and why she would pull something like this. We had never had any personal conflict that I knew of. My properties were well maintained, my tenants were respectful and quiet, and I paid my HOA dues on time every single month. The next morning, I called the HOA office as soon as they opened at 9. A bored-sounding woman named Peggy answered. "Sunrise Meadows, HOA, how can I help you?" "This is Franklin Anderson. I need to speak with Sharon Patterson about a letter that was delivered to one of my tenants yesterday." "Mrs. Patterson is busy right now. Can I take a message?" "No, you cannot take a message. I need to speak with her today about false information she is spreading about my properties. This is urgent." There was a pause, then some muffled conversation in the background. Finally, Sharon's voice came on the line, dripping with false sweetness. "Mr. Anderson, how can I help you?" "You can start by explaining why you told my tenants at 4521 Desert Bloom that their rental is unauthorized, when I have written approval from the HOA." "I have no record of any such approval," she said, her tone shifting to ice-cold efficiency. "I have reviewed our files extensively, and there is no documentation showing that your properties were properly approved for rental use." "That is impossible. I have the letter right here, signed by Robert Chen in 2020. Mr. Chen is no longer with the board, and any approvals he may have given are subject to review by the current administration. We have determined that proper procedures were not followed, and therefore those approvals are invalid." I could not believe what I was hearing. "You cannot just retroactively invalidate approvals that were given years ago. That is not how any of this works. Mr. Anderson, I suggest you review the HOA bylaws, particularly the sections regarding rental restrictions that were updated last year. You will find that all rental properties must be reapproved annually, and you have failed to submit the required documentation." "What updated sections? I never received any notice about changes to the rental policy." "All homeowners were sent notices last March. If you did not receive yours, that is unfortunate, but it does not exempt you from compliance. Now, if you will excuse me, I have other matters to attend to." "Sharon, wait." But she had already hung up. I sat there staring at my phone, trying to process what had just happened. An annual reapproval requirement. That was absurd. I immediately pulled up the HOA bylaws on my computer and started reading through them. It took me almost an hour to find what she was referring to, buried in an amendment passed during a special meeting in March 2025. The amendment required all rental properties to submit annual renewal applications along with a $250 processing fee. I had never received any notice about this meeting or the amendment. I checked my email thoroughly, searched through my physical mail, and found nothing. Either they had never sent it, or it had somehow gotten lost, but either way, this seemed like a technicality being weaponized against me. Over the next week, things escalated quickly. My other 2 tenants called with similar stories. Sharon had visited each of them personally, telling them their rentals were unauthorized and that they should start looking for new places to live. One of my tenants, a retired school teacher named Dorothy Williams who lived at 4598 Desert Bloom, was nearly in tears when she called me. "Franklin, I am 73 years old," she said, her voice shaking. "I cannot handle moving again. I just got settled here after my husband passed. Please tell me I do not have to leave." "Dorothy, you are not going anywhere," I assured her, though I was seething inside. "This is all a misunderstanding that I am going to straighten out. You have a valid lease, and I have every right to rent that property." But Sharon was not done. A few days later, I got a call from a prospective tenant who had been interested in renting my 4th property, which had just become vacant. The caller, a man named James Peterson, sounded apologetic. "Mr. Anderson, I am sorry, but we have decided not to move forward with the rental. We drove by the property yesterday, and a woman from the HOA approached us. She told us the property was involved in legal disputes and that we should avoid renting there. We just cannot risk getting involved in something complicated right now." That was the final straw. Sharon was not just harassing my current tenants. She was actively interfering with my ability to rent out my properties. This was costing me real money and causing genuine distress to people who had done nothing wrong. I called my lawyer, a sharp woman named Patricia Gomez who had handled the closings on all my properties. Patricia practiced real estate law in Scottsdale and had a reputation for being tough but fair. "Franklin, good to hear from you," she said when her secretary put me through. "What can I do for you?" I explained the entire situation, from Sharon's visits to my tenants to the phone call with the prospective renter. Patricia listened without interrupting, and I could hear her typing notes as I talked. "This is textbook tortious interference," she said when I finished. "The HOA president is intentionally interfering with your existing contracts and your ability to form new contracts. The fact that she is doing it based on invalid reasoning makes it even worse. What can we do about it?" "First, I am going to send a cease and desist letter to the HOA and to Sharon Patterson personally. That will put them on notice that their actions are unlawful and that we are prepared to take legal action. Second, I want you to document everything. Every interaction with tenants, every phone call, every email. Get statements from your tenants about exactly what Sharon said to them. And if the cease and desist does not work, then we file a lawsuit for tortious interference and possibly seek an injunction to prevent her from contacting your tenants. Depending on how much financial damage you have suffered, we might also seek monetary damages." "How much is this going to cost me?" Patricia was quiet for a moment. "I am not going to lie to you, Franklin. Litigation is expensive. But you also cannot let someone destroy your livelihood. Let me send the cease and desist first. Sometimes that is enough to make people back off once they realize they are on shaky legal ground. We can reassess after we see how they respond." The cease and desist letter went out 2 days later. Patricia drafted a detailed 5-page letter outlining all of Sharon's actions, explaining why they constituted tortious interference, and demanding that she immediately stop contacting my tenants and making false statements about my properties. The letter also demanded that the HOA formally acknowledge that my rental approvals were valid and provide written confirmation to each of my tenants. I thought that would be the end of it. I really did. But I had underestimated Sharon's stubbornness and her apparent conviction that she was on some kind of righteous crusade. Instead of backing down, the HOA hired their own lawyer, a man named Richard Dunham, who sent back a dismissive response claiming that the HOA was simply enforcing its rules and regulations, that Sharon had acted within her authority as president, and that I was the one who was out of compliance. The response letter conveniently ignored all the evidence I had provided showing that my properties were approved, and that I had never been properly notified of any policy changes. "They are going to fight this," Patricia told me over the phone after receiving Dunham's response. "Which means we need to decide how you want to proceed. We can file the lawsuit, or you can try to go through the HOA's internal dispute resolution process. What would that involve?" Most HOAs have a procedure for resolving disputes between homeowners and the board. You would request a hearing before the full board, present your case, and they would vote on how to resolve it. "Sharon controls the board," I pointed out. "She has her friends in the other positions. There is no way I get a fair hearing." "That is what I figured you would say." In that case, we need to file the lawsuit. I will start drafting the complaint today. The complaint was filed in Maricopa County Superior Court 3 weeks later, in early November. We sued both the Sunrise Meadows Homeowners Association and Sharon Patterson individually. The lawsuit alleged tortious interference with existing contracts, tortious interference with prospective business relationships, defamation, and violation of Arizona's HOA statutes. We sought compensatory damages for lost rental income, punitive damages, attorney fees, and an injunction preventing Sharon from contacting my tenants or making false statements about my properties. The local media picked up the story almost immediately. HOA disputes were apparently big news in the Phoenix area, where aggressive homeowner associations had become a major source of frustration for residents. A reporter from the Arizona Republic called me for an interview, and I decided to speak with her. The article that ran a few days later was titled, "Rental Property Owner Sues HOA President for Alleged Interference." It laid out the basic facts of the case and included a comment from Sharon, who claimed she was simply doing her job and that rental properties were negatively affecting property values in Sunrise Meadows. The article's publication seemed to open floodgates. I started getting calls and emails from other homeowners in the community who had their own horror stories about Sharon's tenure as HOA president. One man told me Sharon had fined him $500 because his grass was half an inch taller than the HOA rules allowed. A woman said Sharon had threatened to put a lien on her house because she painted her front door a shade of red that was supposedly not on the approved color list, even though 3 other houses on the street had similar red doors. The most disturbing call came from Robert Chen, the former HOA president who had approved my rental properties. Robert had moved out of Sunrise Meadows about a year earlier, but he still kept in touch with some people in the neighborhood. "Franklin, I saw the article about your lawsuit," he said. "I wanted to reach out because I think you should know something. When I was president, Sharon was constantly pushing for stricter rules about rentals. She had this idea that renters were somehow inferior to owners and that they were bringing down the neighborhood. I pushed back against her because I thought it was discriminatory and unfair. That is part of why I approved your rentals without any issues. You were a responsible landlord with good tenants." Did she say anything specific about my properties back then? Not that I remember. But after I left the board, I heard through the grapevine that Sharon was targeting homeowners who had rentals. She apparently made comments at board meetings about wanting to phase out rentals entirely. I think she sees this as a way to push her agenda. This information was valuable, and I immediately passed it along to Patricia. It helped establish that Sharon's actions were not really about enforcing HOA rules, but about pursuing a personal vendetta against rental properties. As we moved into December, the discovery phase of the lawsuit began. Patricia served requests for documents on the HOA and Sharon, demanding copies of all communications related to my properties, records of board meetings, the HOA's complete files on rental approvals, and communications between Sharon and my tenants. The HOA's responses were slow and incomplete. They claimed certain documents did not exist or had been lost. They heavily redacted others, claiming attorney-client privilege. Patricia filed motions to compel, and we ended up in front of a judge, arguing about what documents needed to be produced. Meanwhile, Sharon continued her campaign against my properties, although she was more subtle about it now that litigation was pending. I learned from Miguel that she had driven by his house multiple times, parking across the street and just sitting there watching, which was creepy and intimidating. Dorothy told me that Sharon had started filing noise complaints against her, claiming she was playing loud music late at night, which was absurd given that Dorothy went to bed at 9 every evening and mostly listened to classical music at low volume. Each of these incidents got documented and added to our evidence file. Patricia said it was actually helpful that Sharon could not seem to help herself, as it showed a pattern of harassment that would support our claims. The real breakthrough came in January when we deposed Sharon. A deposition is a formal proceeding where attorneys get to question witnesses under oath before trial. Patricia had been looking forward to this for weeks. The deposition took place in Richard Dunham's law office in downtown Phoenix. Sharon showed up wearing a navy blue suit and a pinched expression, clearly unhappy about having to answer questions. The court reporter swore her in, and Patricia started with some basic background questions before getting to the meat of the matter. Mrs. Patterson, when did you first become aware that Mr. Anderson owned rental properties in Sunrise Meadows? I do not recall exactly. Sometime after I joined the board. And what was your reaction when you learned he had rental properties? Sharon hesitated, glancing at her lawyer. I did not have any particular reaction. Patricia pulled out a document. I am showing you what has been marked as Exhibit 12, which is an email you sent to the HOA board in February 2025. Could you read the highlighted portion out loud? Sharon's face tightened. Is this really necessary? Please read the highlighted portion, Mrs. Patterson. She cleared her throat. Rental properties are a plague on our community. They attract transient residents who have no investment in maintaining property values or community standards. We need to find legal ways to restrict or eliminate rentals in Sunrise Meadows. Did you write that email? Yes, but that was taken out of context. We will get to context in a moment. Did you specifically discuss Mr. Anderson's properties in board meetings? I may have mentioned them. Patricia pulled out another document. Exhibit 18 is the minutes from a board meeting in June 2025. According to these minutes, you stated, and I quote, "The Anderson properties are priority targets for enforcement action." Is that accurate? I was referring to ensuring compliance with HOA rules. But Mr. Anderson's properties were in compliance, were they not? He had written approval from the previous board. Those approvals were not properly documented. Actually, we have the approval letter right here, properly signed and filed with the HOA. Did you review that letter before telling Mr. Anderson's tenants that the rentals were unauthorized? Sharon shifted in her seat. I reviewed what was in the current files. So you are saying the approval letter was not in the current files? I did not see it. Did you ask anyone about whether previous approvals had been given? I relied on what I could find in the files. Patricia leaned forward slightly. Mrs. Patterson, is it not true that you personally removed documents related to rental approvals from the HOA files after you became president? Richard Dunham jumped in. Objection. That is completely unfounded and inappropriate. I am entitled to ask the question, Patricia said calmly. Mrs. Patterson, did you remove or destroy any documents related to rental property approvals? No, Sharon said, but her voice wavered slightly. We will see about that. Let us move on. On September 8, 2025, you visited the property at 4521 Desert Bloom Drive and spoke with Miguel and Sofia Rodriguez. What was the purpose of that visit? I was conducting routine inspections of properties in the neighborhood. Do you routinely enter private property to speak with residents? I did not enter the property. I spoke with them at the door. And you told them their rental was unauthorized, correct? I informed them that there were questions about the property's compliance status. Did you tell them they might need to vacate within 30 days? Sharon paused. I may have mentioned that as a possibility if compliance issues were not resolved. Did you have any legal authority to make that statement? I am the HOA president. That was not my question. Did you have any legal authority to tell tenants with valid leases that they might need to vacate? I was providing them with information that turned out to be false, correct? I was acting based on the information I had at the time. The deposition continued for nearly 4 hours. Patricia systematically went through each instance of Sharon contacting my tenants or interfering with prospective renters. By the end, Sharon looked exhausted and angry, and several of her answers had been contradictory or evasive in ways that would not play well in front of a jury. After the deposition, Patricia and I grabbed coffee at a shop near her office. That went well, she said, reviewing her notes. Sharon is going to be a terrible witness at trial. She is combative, she contradicts herself, and her bias against rental properties is obvious. You think we will actually go to trial? I asked. Hard to say. Sometimes after a bad deposition, the other side realizes they are in trouble and becomes more willing to settle. But Sharon seems pretty dug in, and the HOA might feel like they need to back their president even if she has made bad decisions. Patricia was right about Sharon being dug in, but wrong about the HOA's willingness to keep backing her. A few weeks after Sharon's deposition, I got a call from Patricia with surprising news. I just got off the phone with Richard Dunham, she said. Apparently, there has been a revolt within the HOA board. 3 of the 5 board members have called for Sharon's resignation, and they want to discuss settlement options. Why the sudden change? From what Dunham told me, some of the board members were not fully aware of the extent of Sharon's actions. After her deposition testimony started circulating and more homeowners came forward with complaints, they realized she had been acting beyond her authority and potentially exposing the HOA to significant liability. So they are throwing her under the bus, pretty much. Which actually works in our favor. The HOA has more money to pay a settlement than Sharon does individually. The settlement negotiations took place over the next month. The HOA offered to formally acknowledge that my properties were approved for rentals, provide written confirmation to all my tenants, remove any documentation suggesting otherwise from their files, and pay $15,000 in damages, plus my attorney fees. It was not a bad offer, but it did not hold Sharon personally accountable, and it did not compensate me for all the stress and lost opportunities. I had lost out on at least 2 months of rent on my vacant property because of Sharon's interference, plus the emotional distress caused to my tenants. Patricia and I countered with a demand for $45,000 in damages, full attorney fees, a written apology from both the HOA and Sharon personally, and a requirement that Sharon resign from the HOA board. The negotiations went back and forth. The HOA was willing to go up to $30,000, but they balked at requiring Sharon's resignation, saying they could not force her to resign. I was prepared to walk away from settlement and go to trial when something unexpected happened. In early March, I got a call from Peggy, the administrative assistant at the HOA office. She sounded nervous. "Mr. Anderson, I probably should not be calling you, but I thought you should know something." "What is it?" "I was cleaning out some old file cabinets in the storage room, and I found a box of documents that had been hidden behind some other boxes. There were rental approval letters in there, including yours. They all had dates from when Mr. Chen was president." My heart started racing. "Are you saying someone deliberately hid those documents?" "I do not want to accuse anyone, but those boxes were pushed way back in a corner where nobody would normally look." And I remember Sharon telling me to reorganize the storage room right after she became president. She said she wanted to make space and that I should move some boxes around. Peggy, this is incredibly important. Would you be willing to testify about this? She hesitated. I do not want to lose my job. I understand, but what Sharon did was potentially criminal. She deliberately hid documents and then used their absence as justification to harass my tenants and interfere with my business. This is not just an HOA dispute anymore. Let me think about it. But I wanted you to know about the documents. I put them back in the main files where they belong. I immediately called Patricia and told her about Peggy's call. Patricia's reaction was swift. If what Peggy says is true, we are talking about fraud and possibly criminal mischief. We need to amend our complaint to add fraud claims, and we should consider referring this to the county attorney's office for criminal investigation. Will Peggy's testimony be enough? It would be helpful, but we might not need her if we can prove the documents were hidden. I am going to file an emergency motion for the court to take possession of those files and appoint a forensic examiner to review them. If we can show that Sharon deliberately concealed those documents, it completely changes the case. The emergency motion was filed the next day. The judge held a hearing within a week, and Richard Dunham showed up looking distinctly uncomfortable. He tried to argue that the motion was unnecessary, that the documents had simply been misfiled, and that there was no evidence of any intentional concealment. Patricia countered with Peggy's statement, which she had agreed to provide in a sealed affidavit. The judge read the affidavit, asked a few pointed questions, and then ordered that all HOA files be turned over to a court-appointed examiner for review. The examiner's report came back 3 weeks later, and it was damning. The report confirmed that multiple rental approval documents had been stored in a location separate from the main files, that they showed evidence of being deliberately concealed rather than simply misfiled, and that the concealment had occurred shortly after Sharon became HOA president. The report also found that Sharon had failed to maintain proper records of board meetings and had made decisions without proper board authorization on multiple occasions. Armed with this report, Patricia filed an amended complaint adding claims for fraud, fraudulent concealment, and violation of Arizona's consumer fraud statutes. We also filed a formal complaint with the Maricopa County Attorney's Office. The pressure on Sharon became enormous. The remaining HOA board members held an emergency meeting and voted to suspend her as president pending the outcome of the litigation. Several homeowners filed their own complaints against her. The local news picked up the story again, this time with the headline HOA president accused of hiding documents in rental property dispute. Sharon's lawyer withdrew from representing her individually, citing irreconcilable differences. The HOA's insurance company sent their own lawyers to handle the case, and those lawyers immediately reached out to Patricia about settlement. The final settlement was reached in late April. The terms were significantly better than what had been offered before. The HOA agreed to pay $60,000 in damages and compensatory payments, which covered my lost rent, my attorney fees, compensation for the distress caused to my tenants, and punitive damages. They provided written confirmation to all my current and prospective tenants that my properties were fully approved for rental. They issued a formal written apology acknowledging that their actions had been inappropriate and harmful. Sharon Patterson was required to personally pay an additional $20,000 from her own funds, issue her own written apology, resign immediately from the HOA board, and agree not to seek any position with the HOA for at least 5 years. She also agreed to have no contact with me or my tenants going forward. The settlement agreement was finalized in early May, about 8 months after this whole nightmare had started. But the story did not quite end there. In July, I got a call from a detective with the Maricopa County Sheriff's Office. Detective Maria Santos explained that they had been investigating Sharon's actions based on the complaint we had filed and the evidence developed during the civil litigation. "Mr. Anderson, I wanted to let you know that we are moving forward with criminal charges against Sharon Patterson," Detective Santos told me. "We are charging her with fraud, tampering with public records, and criminal interference with a business." "I did not realize HOA documents counted as public records," I said. "Under Arizona law, HOA records are considered semi-public documents that members have a right to access. Deliberately concealing or destroying them can be charged as tampering with records." Combined with the fraud she committed by making false statements to your tenants and the interference with your business, we believe we have a solid case. The criminal case moved slowly through the system, as these things tend to do. Sharon initially pleaded not guilty and tried to fight the charges, but the evidence against her was overwhelming. In November, almost 14 months after she had first shown up at Miguel's door, Sharon accepted a plea agreement. She pleaded guilty to 1 count of fraud and 1 count of criminal interference with a business. The other charges were dismissed as part of the plea deal. She was sentenced to 2 years of supervised probation, 300 hours of community service, a $5,000 fine, and an order to pay additional restitution to me for the costs associated with the criminal investigation. The judge who sentenced her was a no-nonsense woman named Judge Helen Vasquez, who had clearly read the case file thoroughly. "Mrs. Patterson, I have been on the bench for 15 years, and I have seen a lot of HOA disputes come through this court," Judge Vasquez said during the sentencing hearing. "Most of them involve neighbors who cannot get along or legitimate disagreements about rules and regulations. But your case is different. You deliberately concealed documents, made false statements to innocent tenants, and interfered with a legitimate business, all because of your personal bias against rental properties. Your actions caused real harm to real people, including elderly and vulnerable individuals who were worried about losing their homes. That kind of behavior is not just inappropriate, it is criminal. I hope this sentence sends a clear message that people in positions of authority within HOAs cannot abuse that authority to pursue personal vendettas." Sharon stood there silently, her lawyer beside her, as the judge pronounced the sentence. She looked much older than she had when this all started, worn down by the stress of the litigation and criminal prosecution. As for me, I walked out of that courthouse feeling a mix of emotions. I was relieved that justice had been served and that Sharon had been held accountable. I was satisfied that my tenants could live in peace without fear of harassment. But I was also exhausted from the whole ordeal and frustrated that it had taken so much time, money, and effort to resolve something that never should have happened in the first place. The new HOA board, which had been completely turned over with fresh elections, reached out to me personally to apologize and to assure me that they wanted to start fresh. They implemented new policies requiring transparency in board decisions, mandatory training for board members on Arizona HOA law, and a formal dispute resolution process for conflicts between the board and homeowners. Miguel and Sofia sent me a gift basket around Christmas, thanking me for fighting to protect their home. Dorothy baked me cookies and left them on my doorstep with a note saying she could finally sleep peacefully knowing Sharon was gone. My other tenants expressed similar gratitude. I was eventually able to rent out my vacant property to a nice young family from California who were relocating to Phoenix for work. When they asked about the HOA during their walkthrough, I was able to honestly tell them that things had improved dramatically. Looking back on the whole experience, I learned several important lessons. First, documentation is everything. The fact that I had kept copies of all my approval letters, emails, and correspondence with the HOA was crucial to proving my case. Second, standing up to bullies is important, even when it is expensive and stressful. If I had backed down and accepted Sharon's claims, she would have continued targeting other homeowners with impunity. Third, not all HOA board members are bad people. Many of them are well-intentioned volunteers who genuinely want to serve their community. The problem arises when someone like Sharon gets into a position of power and abuses it. I also developed a deeper appreciation for the legal system, despite its flaws and frustrations. Yes, the litigation was expensive and time-consuming. Yes, the process often felt maddeningly slow. But ultimately, the system worked. The truth came out, justice was served, and the wrongdoer was held accountable both civilly and criminally. The settlement money I received helped offset my losses and legal costs, though I cannot say I came out ahead financially when all was said and done. But some things are worth fighting for beyond just money. My reputation as a landlord was preserved. My tenants were protected. And Sharon Patterson learned that there are consequences for abusing authority and harming others. In the months that followed, I became something of an informal advisor to other homeowners in Phoenix who were dealing with HOA disputes. People would reach out to me through mutual friends, or after seeing the news articles about my case, asking for advice about how to handle conflicts with their own associations. I always gave them the same guidance. Document everything, know your rights, do not be afraid to lawyer up if necessary, and remember that most disputes can be resolved through calm communication and compromise, but some require you to stand firm and fight. One case that particularly stood out involved a man named Timothy who lived in a different HOA community in Scottsdale. His HOA was trying to force him to remove solar panels from his roof, claiming they violated aesthetic guidelines. I connected him with Patricia, who pointed out that Arizona law specifically protects homeowners' rights to install solar panels and prohibits HOAs from banning them. Armed with that information, Timothy was able to resolve his dispute without litigation, though he had to threaten legal action to get the HOA to back down. Another person, a woman named Linda, was dealing with an HOA that was trying to fine her for running a home-based business, even though she was just a freelance writer who worked from her home office. I helped her understand that HOAs generally cannot prohibit home-based businesses that do not generate traffic or disturb neighbors, and she successfully fought off the fine. These smaller victories felt meaningful in their own way. I could not fix all the problems with HOAs, but I could help individual people navigate difficult situations and stand up for their rights. As for Sharon Patterson, I heard through the neighborhood grapevine that she moved out of Sunrise Meadows about 6 months after her sentencing. Someone told me she had relocated to a different part of Phoenix, though I did not know or care about the specifics. I hoped she had learned from the experience, but I also knew that some people never change. The Sunrise Meadows community slowly recovered from the drama and dysfunction of Sharon's tenure. Property values remained stable, and the neighborhood actually became more attractive to potential buyers because the new HOA board was so much more reasonable and transparent. Several new families moved in, and the sense of community improved as people felt less worried about arbitrary enforcement actions and personal vendettas. I continued to manage my rental properties, and they continued to provide steady income that helped me build financial security for the future. I had learned to be more vigilant about HOA communications and to attend board meetings regularly to stay informed about any proposed rule changes. I also made sure to build positive relationships with the new board members, so they knew I was a responsible property owner who cared about the community. One evening in early spring, almost 2 years after the whole ordeal had begun, I was sitting on the back patio of my own home in Sunrise Meadows, watching the sun set over the desert landscape. Miguel and Sophia walked by with their toddler, and we waved to each other. Dorothy was tending to her garden next door, humming to herself. Everything felt peaceful and normal in a way that had seemed impossible during the darkest days of the conflict with Sharon. My phone buzzed with a text from Patricia. We had stayed in touch after the case concluded, occasionally grabbing lunch or coffee to catch up. Her message said she had just settled another HOA case where a board member had been harassing a homeowner, and she wanted to thank me for referring the client to her. I texted back congratulations, then set my phone down and just enjoyed the quiet evening. I thought about how strange life can be, how quickly situations can spiral out of control, and how important it is to stand up for what is right even when it is difficult. The whole experience had been exhausting and frustrating, but it had also been clarifying. I knew now that I had the strength to fight back against injustice, that I could navigate complex legal situations with the right help, and that taking a stand often inspires others to do the same. I also had a newfound appreciation for the simple pleasure of living in a community where you do not have to worry about your HOA president showing up at your door with false accusations or hidden agendas. The new board was not perfect, but they were honest and reasonable, which was all anyone could really ask for. As darkness fell over the neighborhood and lights began twinkling on in houses up and down the street, I felt genuinely grateful for how things had turned out. Yes, I had lost time and money. Yes, the stress had taken a toll on me and my tenants, but we had come through it together, stronger and more informed than before. And Sharon Patterson had learned an important lesson about the consequences of abusing power, a lesson that was reinforced not just by the civil judgment against her, but by her criminal conviction. That record would follow her for the rest of her life, a permanent reminder that actions have consequences, and that you cannot treat people badly just because you happen to hold a position of authority. In the end, justice had been served, my properties were secure, my tenants were safe, and Sunrise Meadows was a better community for everyone. That was worth fighting for, and I would do it again in a heartbeat if I had to. But as I finished my drink and headed inside for the night, I sincerely hoped I would never have to go through anything like that again. Once was definitely enough.